With COVID-19 cases again on the increase, the government announced a return to level 2 on the 31st of May. Just as we were getting to grips with that, the confirmation of a third wave, at least in Gauteng, pushed us to level 3 this week. What does this mean for tenants and landlords? Hi, I'm Simon Dippenaar and I'm an attorney. The rules regarding evictions have basically not changed throughout alert levels 1, 2, 3, but it's worth going over them again. Every time the alert level changes, I get queries from clients regarding what is permitted. So here's a recap of the eviction regulations under alert level 3 and the eviction process. As before, the aim is to protect vulnerable tenants. The regulations state a person may not be evicted from his or her land or home or have his or her place of residence demolished for the duration of the national state of disaster unless a competent court has granted an order authorizing the eviction or demolition, unquote. Landlords may apply for an eviction order, but it will be suspended until after the lapse or termination of a national state of disaster unless the court is of the opinion that it is not just or equitable to suspend or stay the order, unquote. A landlord needing to evict a tenant must have regard for the need for everyone to have a place of residence and services to protect their health and the health of others, the impact of the disaster on the parties, whether affected persons will have immediate access to an alternative place of residence and basic services, whether adequate measures are in place to protect the health of any person in the process of a relocation, the occupier's behavior, for example, if they are causing harm to others, the steps the landlord has taken to make alternative arrangements for payment of rent, and a number of other considerations. These are spelled out in the Government Gazette, which is available online. The Gazette stresses the importance of fair practice, strengthening the provisions of the Rental Housing Act. Unfair practices include terminating a lease without giving proper notice, reasonable notice, or allowing the tenant to make arrangements regarding alternative payment arrangements if necessary, imposing a penalty for the late payment of rental where the default is caused by the disaster, failure of either landlord or tenant to engage reasonably with the other to cater for the exigencies of the disaster. Any other conduct that prejudices the ongoing occupancy of the health of any person or the ability to comply with the restrictions on movement. Although the eviction order may be stayed until after the national state of disaster lapses, you may apply to the court for an eviction order if your tenant is in breach of your lease agreement. It's a good idea to work with an eviction attorney from the start. If the breach is not remedied and you pursue the matter through the courts, it's important to follow due process every step of the way. Rental housing legislation is complex and especially right now rapidly changing. You need to be sure you are in compliance with the law and more importantly your tenants are treated fairly. My law firm SD Law is a specialist in eviction law. If you are seeking an eviction, we will make sure you meet the court's requirements and give us a call on 086 099 5146 to discuss your situation.